Hi, you're here today with Joe Wallace. I am the producer of The Joe Wallace Show. We've been broadcasting in Southeast Queens for several years now. Today we're going to talk about the foreclosure process as it relates to the court system. First, a little background about myself. In addition to being the producer of The Joe Wallace Show, I publish a community newspaper called The Opportunity. And I also have a foreclosure business called North American Foreclosure Solutions. In addition to that, I'm the author of a book called the Stop Foreclosure Auction Toolbox, which teaches people in foreclosure how to go into court to either stop, dismiss, or delay the foreclosure process. It teaches a person in foreclosure how to exercise their rights in court, which many people are unaware of, that there are a lot of things that one can do in court to challenge the foreclosure process. A little more background about myself. I was born and raised in New York City. My parents are from New Orleans, Louisiana. That's where the hurricane hit, Hurricane Katrina. Both of them came to New York before I was born, and shortly after they came to New York, I was born in Brooklyn, and then we moved out to Jamaica, Queens when I was a very young child. Been here all my life since then. Getting into the subject matter, the foreclosure process in certain states must go through the court system. There are some states where the foreclosure process does not have to go through the court system, and in those states the foreclosure process proceeds very quickly. The states that require the bank to go into court, the foreclosure process takes a little more time. The states that require court action are called judicial states, and the states that don't require the bank to go into court are called non-judicial states. The state of New York is a judicial state, which means that anywhere in the state of New York, if a bank wishes to foreclose on a home, they must go through the court process. So what happens with foreclosure? Basically, when the bank sees that the homeowner is missing payments, it could be one payment, usually it's two or three at least, and usually over an extended period of time, the bank will finally put their foot down and decide that they want their money back and that they're going to take legal action, also known as starting the foreclosure process. And that's when they formally start the foreclosure process. Now, certain things happen when you are formally in the foreclosure process. For one thing, the bank stops accepting money. If you send once the foreclosure process starts, you send your monthly mortgage payment and the bank will send it right back. And the reason for that is, to start the foreclosure process, the bank has to hire lawyers and go into court. They file what's called the list pendants, and they also start the process with something called a summons and complaint. So they go through a lot of trouble to start this process. If they accept payments from the homeowner after that process is started, the process is canceled. So that's why the bank will not accept your money once the foreclosure process starts. Now, before we go any further, there's a very important point that I want to make about what happens when the bank stops accepting your payments. This is the most important thing I'm going to say in the whole show. Put that money aside. If the bank stops accepting your payments, don't go on a spending spree. Now all of a sudden you have an extra, whatever your mortgage payment is, you have that amount of money at your disposal, and some people go to the shopping mall. The bank is not accepting their payments, so they go out and buy a TV or buy some new clothes. I really want to emphasize that that is the wrong thing to do. When the bank stops accepting your payments, it's very, very important to put that money aside. Open up a separate savings account and put that mortgage payment in that savings account just like you were paying it to the bank. And the reason for that is, as the foreclosure process moves along, there are a lot of different possibilities of working something out with the bank. And if you have no money, if you've spent all of those months of mortgage payments and you did not set it aside, when it comes time to work out something with the bank, they're almost always going to ask for some kind of good faith payment, and it could be substantial. For example, if several months have passed while you're in foreclosure and you haven't been making the payments, now you owe the bank $30,000 or $40,000. if you're going to do a workout agreement with them, they're going to want $10,000 or $15,000 down. And if you've spent all your mortgage payments during those months, you will have nothing to give them. So it's very important to set that money aside. It's a very powerful negotiating tool as you move forward and you're trying to work something out with the bank. But to continue with the court process, the first steps are the bank goes into New York State Supreme Court in the state of New York, which is a judicial state, and files what's called a summons and complaint. And they also file something called a lis pendens. Lis pendens is simply notice to the court and the world at large that a lawsuit or an action is pending against that particular property. The summons and complaint, though, more important, is notification to the homeowner that they must appear in court to answer the foreclosure lawsuit. And the other mistake a lot of people make is they do nothing when they get the summons and complaint. It's another very important message is that when you get the summons and complaint, you will be served with that. Someone will knock on your door or they'll mail it to you. They have to, by law, they have to serve you with that paperwork. When you get that paperwork, it's very important to make a plan of action and decide what you're going to do and how you're going to proceed, because if you do nothing, the foreclosure process will move through the court system unchallenged. And what happens is eventually the court will award the bank a judgment of foreclosure. If you do nothing, that's what's going to happen. So what happens in that case is that once a judgment is awarded, a lot of the legal remedies that you have at your disposal to challenge the foreclosure action are canceled or waived. Once that foreclosure lawsuit goes into judgment, that's when you have a bigger problem. It doesn't mean it's the end of the world. It doesn't mean you have no other options. But a lot of the things you can do legally stop once that case goes into judgment. An example is many people have gone into court to fight a parking ticket, and you know what they tell you. The judge there says, well, that ticket's in judgment. There's nothing that can be done. Have you had that experience? When you go to fight a parking ticket. Now, if the ticket is not in judgment, you can get a reduction in the amount that's owed. You might be able to get the ticket dismissed if you have a good defense. But once that ticket is in judgment, no matter what your defense is, the court will not hear it, because judgment means a certain finality to any kind of defense that you can raise to challenge that particular issue. So the second important point is, as the foreclosure lawsuit moves through the court process, if you do nothing, eventually it will go into judgment. That usually takes anywhere from 6 months to even up to a year for it to hit the judgment phase, because a lot of things have to be done in the intervening time. So you have time to answer your foreclosure. Formally, there's an official time period where you can put an answer in. But even if you miss that time period, as long as the foreclosure is not in judgment, there's a lot of things you can do in court to challenge that foreclosure lawsuit. The next thing after the judgment is awarded to the bank is that it'll take a few more months to reach the point where the court gives the bank permission to sell the home at the public auction. That's when you are supposed to get a notice of sale, and again, that should be served. Someone will knock on your door and let you know, or they'll mail you a certified mail that your house has been scheduled for auction. Once again, if you do nothing, the house will be auctioned, and after that, there's almost nothing you can do. Although again, there are things you can do, but it's very limited once the house is sold at auction. Then within 2 or 3 months after that, if you don't voluntarily leave, the bank will go into court and get a judgment of eviction, which gives them permission to evict you, and then the marshal will come and take out your possessions and put them in a storage truck and put them in storage, and you'll be locked out of your home, and that's it. Deal is over completely at that point. Again, between the time of judgment and the time your house goes for auction, there are things that can be done to stop this. Now, to continue, going back to the beginning, where the bank first starts the foreclosure action, let's talk a little bit about service, about being served. It's a very important concept in the law. You have to be served with anytime anyone takes legal action against you, they have to notify you, and you have to be served with notice of that legal action. So usually in cases where the bank has started the foreclosure process, the first thing that's going to happen is you're going to get something called the summons and complaint. The summons tells you that you must come to court to answer this lawsuit, and it tells you how much time you have to answer. And then the complaint is a list of the reasons that the bank feels they have a right to foreclose on your home. Now, once again, if you do nothing, the bank gets everything they ask for in court. So at the time that you receive the summons and complaint, there are several things you should be thinking about. One is paying attention to how that service takes place. How were you served? Did someone knock on your door and personally hand deliver a package to you? That's called personal service. Another way that the bank is allowed to serve is by mailing the paperwork. But here's an important point. If there are any defects in the way that you were served, you can have that foreclosure lawsuit dismissed, thrown out. The bank has to start all over again and serve you properly. So pay attention to the way you were served. If they serve your next door neighbor, and your next door neighbor, let's say they serve your next door neighbor by mistake and your next door neighbor drops the papers off, you can go into court and say you were not properly served because they made a mistake in how they served you. Or maybe they serve an underage child in the property. There's a lot of things. Process servers make mistakes all the time. So that's something to pay attention to. How were you served? A lot of people ask me, well, should they open the door when they see a stranger standing on the doorstep with some papers? That's something for you to decide, but again, if there are any defects in the service, you can use that in court later on to have the entire case dismissed. Now, moving forward, the interesting news is that it's been found, and we've been saying this for years, we've been going into court helping homeowners fight foreclosures for many years under our company, North American Foreclosure Solutions. In fact, we've written a book about it, and many of our clients are lawyers. We write the legal defenses for several lawyers who then go into court with that paperwork and challenge foreclosure lawsuits. And what's been happening is the banks have been handing in very sloppy paperwork. The paperwork is often filled with defects. That's why it's important to make a plan of action when you get that summons and complaint. A lawyer will be able to look at your case. He'll look at all the facts of your foreclosure case, look at the paperwork, and a lawyer will look for the defects. We show you how to do that yourself in our book, The Stop Foreclosure Auction Toolbox. Some people would rather have a lawyer. Other people don't have money to hire a lawyer. That's why we wrote the book, so that you can figure this out yourself. You can look for certain defects in the foreclosure paperwork and challenge the bank in court. What's been happening is that the courts have been finding so many defects in the foreclosure paperwork. You might have been hearing about this on the news, that the new filings of foreclosures have slowed down dramatically because the banks have been using these automated services to prepare their court paperwork, and they have been making a lot of mistakes. So when the bank goes into court to start this foreclosure process against you, when they hand in that paperwork, if there are mistakes in that paperwork and you come and challenge those mistakes, you come and say, I found, that the bank was not really holding title to the mortgage at the time they started the foreclosure lawsuit, that foreclosure lawsuit can be dismissed. At the very least, you're going to delay the process by several months by going into court and challenging defects within the foreclosure paperwork. The other reason why it's important to answer the summons and complaint is you're entitled in most cases, especially, well, if it's a subprime loan, if your mortgage falls in a certain category of subprime criteria, you have a right to a court-supervised settlement conference. And that settlement conference is important because here it is, the bank has stopped accepting your payments, your house is moving toward the auction. When you go for the settlement conference, you come with your financial documentation that you can't afford to pay the mortgage, and you do that under the supervision of the court. And the chances are much better at that time of working out some kind of agreement with the bank under the supervision of the court, because when you try to do a settlement on your own with the bank, they're very hard-nosed about it. But when you do it through the court system under the supervision of the court, the bank knows that the court is watching. Your chances of reaching some kind of agreement to get out of foreclosure are much greater by you taking advantage of that mandatory settlement conference, which can only take place at the beginning of the foreclosure process. Once your foreclosure goes into judgment, that settlement conference option is by and large over, although there are cases where you can still get a settlement conference, but it's much harder to do that under the supervision of the court after the case goes into foreclosure, a judgment rather. So again, it's important to take action when you get the summons and complaint. And let's look at the two options. Really what you should do is hire a lawyer. But again, there are people that learn how to do this on their own. It's not that difficult. It's really a question of learning how to prepare the legal paperwork to go into court. There are legal aid lawyers that you can use. In fact, you should go right into court when you get the summons and complaint. Queens County Court and practically every court in the state has counselors there that can help you find a lawyer if you can't afford one, or they'll suggest alternatives. And then, of course, if you like, you can order our book, The Stop Foreclosure Auction Toolbox, which will walk you step by step through the entire process of going into court and mounting your own defense on your own. It's called pro se, meaning you go into court on your own. It takes a little bit of study, but it can be done. And again, we guide you step by step through the whole process. So you go into court with a lawyer. Well, let's talk about why people don't like to hire lawyers. I mean, people have a situation where their house is in foreclosure. They get the summons and complaint, which is a lot of technical legal paperwork. Most people set it aside and they just wait to see what happens next. The right thing to do is go see a lawyer, but the problem with that is, in many cases, people feel they don't have the money to hire a lawyer. A lawyer is going to charge you about $3,000 or $4,000 to take a foreclosure case on. It's worth it because you are able to exercise your rights and protections under the law. However, people in many cases don't trust lawyers. If you don't know what you're doing, if a person feels they don't know anything about the process and they go to a lawyer, they feel the lawyer's going to charge whatever they want and maybe do a good job or not. So that's why people hesitate. But if you feel that you don't have the money for a lawyer, or you feel that you don't trust lawyers, we suggest you go on the internet or purchase our book and learn how to do this yourself. There's a lot of information out there about going into court on your own. And in fact, once again, our book will tell you how to do that step by step. So, whether you hire a lawyer or not, you go into court. Now, the interesting news is that with all the defects that that are in the paperwork that's been submitted around the country, states around the country are investigating the banks for submitting this sloppy paperwork. Attorney generals around the country have opened cases against banks, and practically every state in the nation. And that's, again, why the foreclosure process has really slowed down. The banks are trying to get their paperwork in order. But if you're in foreclosure now, chances are you have a lot of defects in that paperwork. If you take a look at your mortgage and see that mortgage electronic registration systems is involved in your mortgage, that means you have a very, very strong likelihood of being able to go into court and really give the foreclosing bank a hard time. In fact, you have a possibility of getting the foreclosure action dismissed, and where the bank will have to start all over again. The other important point to remember is that this is something you'll have to learn how to do. So when you get that summons and complaint, don't set it aside. Make a plan of action, whether it's to hire a lawyer or whether it's you're going to study your options and rights, or whether you're just going to take a walk or take the bus or drive down to the courthouse and ask them what to do. But do something. Don't just do important. I know you're under a lot of stress and you don't know where to turn or what to do, but do something. Either get a lawyer, go to the court, or buy our book and start finding out how to challenge this. Do it right away. Don't wait. Now let's talk about what happens when your house is now ready to be auctioned. The foreclosure process is taken. The bank has gone through the court process, and they've reached the point where they're ready to auction your house. Does that mean that all of your options are over? No, not at all. In fact, from the time that auction is scheduled, if you know what you're doing, you can delay the foreclosure process easily by a year, and in some cases up to 2 years. And why would you want to delay the process? Well, obviously, if you have more time in your home, you have more time to fix the problem. If you've been laid off, for example, now you have more time to find a job. If you need time to move, now you have extra time to find a new place to live and get yourself together to move out. So what the very important point we're making now is, even if the house is about to be auctioned, you can do things to delay that process. Let's talk about the two options that you have. The two main options are, one, by filing a chapter. If your house is about to go to auction, you can stop the auction by filing a Chapter 13 bankruptcy. It's a few papers that you have to fill out, and once you file that bankruptcy, the auction must be stopped. Now, typically, when you take that route, when you file a Chapter 13 bankruptcy, if you file just the bare minimum of paperwork, you'll get about 6 to 8 months more time in your house. And guess what? You can file 2 of them in 1 year. So, for example, you have an auction schedule for, today is Monday, you have an auction schedule for Friday. You go into the bankruptcy court on Thursday afternoon and file a Chapter 13 bankruptcy. That Friday auction will be canceled, and it will remain canceled until that bankruptcy is dismissed. And again, if you file the minimum paperwork, it could take up to 6 months easily for that bankruptcy to be dismissed. So then another couple of months goes by, and the bank schedules another auction. When that happens, you can file another bankruptcy. So you can file up to 2. And the other issue to remember is that if both husband and wife are on the mortgage or are on the deed, each of them can file up to 2 bankruptcies. So on the first bankruptcy, you might get 6 months, 7 months. On the second one, it's less time because they're a little more strict on the second filing. You might get maybe 3 or 4 months, or as little as 2 to 3 months. So we're talking almost a year for one person filing 2 bankruptcies. That was the husband. Now the wife comes along. When the auction comes, she goes and files a bankruptcy. And then the next auction, she files another one. You've just bought almost 2 years in your house by filing the bankruptcies. And again, that may give you the time to get your act together and save your home in another way. You might be able to work out a loan modification, or you might need time to do a short sale, or you really need to make more money. If you can't afford your mortgage, maybe you'll have time to get that second job, or start making one of your children who's living in the attic pay rent, whatever. Time is good because it gives you options. So bankruptcy, Chapter 13 bankruptcy is one option for delaying the mortgage process. And you can do that at any time. Generally, people will do that right before the auction. And that's not something you would do right after you get a summons and complaint. Now, let's talk about the second option for delaying or extending the foreclosure process. The second option is going into court to challenge the foreclosure process, to find the defects and get the foreclosure lawsuit delayed or dismissed. Just by going into court, you're going to get a few months of delay. However, if you're one of those people that did nothing and your home went into, your foreclosure case went into judgment and your house is about to be auctioned, at that time you can also go into Supreme Court and file what's called an order to show cause with a temporary restraining order. Again, generally speaking, you need a lawyer to do this. A lawyer will charge $2,000 or $3,000 to go into court to stop an auction with an order to show cause. Again, we show you exactly how to do this in our book, the Stop Foreclosure Auction Toolbox. You can buy that book, and it walks you step by step through exactly how to file the Chapter 13 bankruptcy paperwork, when to do it, how to do it, where to do it. In fact, you even get sample forms that are filled in that show you exactly how to put the Chapter 13 bankruptcy paperwork together. Of course, that's the initial paperwork just to stop the auction. Same is true with the order to show cause. If your house is about to be auctioned and you've done your 2 bankruptcies, for example, so you have no more option with the bankruptcy, you can then go into court with an order to show cause, and provided that you have good defenses. For example, if we find that the bank has made mistakes in the way they are handling your foreclosure lawsuit, right before the auction, you can go into court with that order to show cause and have that auction postponed. And again, it takes a little expertise to do that. You have the choice of hiring a lawyer at $2,000 or $3,000. You also have the option of purchasing our book, or you can go into court and see if you can find legal assistance from some of the agencies that help people that don't have the money to hire a lawyer. But when you file that order to show cause and the judge signs it, that auction is stopped. That will give you about 6 months. If the defects in the bank's foreclosure paperwork are serious, the entire foreclosure case may be dismissed even after judgment, although again, it's much harder to dismiss after judgment. But the point I'm making is that from the time of your first scheduled auction, you can easily extend the foreclosure process by 1 or 2 years. I mean, you'll have to do some work, but you can buy that amount of time. So it might have taken 1.5 years to get to the point where your house is now going up for auction. You could add another 2 years to that, and that's a significant thing, because when people first get that notice that they're in foreclosure, they go into panic and they feel, well, I'll be out of my house soon. One of the things we want to do is try to relieve your stress by educating you to the fact that even if you've done nothing and your house is about to be auctioned, if you take the right steps, you can extend that process by another 1 or 2 years. So let's say that it took 1.5 years. You got the notice of summons and complaint. You now it's going to take a good 1 year to 1.5 years or even more for it to reach the point where they can sell your house at auction. And again, the bank has to go through this entire legal process in the state of New York or any judicial state before they can sell your property. So then, so it's taken 1.5 years, and now if you take the right steps, you can stretch it out another 1.5 to 2 years. So from the time you get that summons and complaint, you might still be in your house for another 2 or 3 years. So you don't have to panic. What you have to do is start educating yourself and learning your legal rights and how to exercise them. Get involved in the process. Go stop by the court. Every court has an office to help people who don't have attorneys. The courts now have a lot of referral services where they might refer you to a legal aid type attorney. And again, you can go online. There's a tremendous amount of information online about defending foreclosure cases. And of course, an easy way to do this is just order our book, where we walk you step by step through the whole process of preparing a foreclosure defense, preparing an order to show cause to stop an auction. But the good news is that if you learn about your rights, you can really extend that process, buy a lot of time, and look for other remedies to get out of foreclosure. So that's our show for today. We're going to continue on this topic and go into more detail about exactly how to defend against a foreclosure case in court.